Folks, white folks in Texas widening, a Republican judge sided with the school district when it came to a black teen wearing locks. And remember, Texas passed the Crown Act, which outlawed hair discrimination in government jobs when it comes to school as well. But the judge says, no, the school district's hair policy is just, and the young man who has been in-school suspension, well, he does not win his case. Barbers Hill ISD, the judge ruled that they did not violate the Crown Act for disciplining Darryl George. That decision came down today. Chambers County Judge Chap B. Cain III sided with the school district, saying that his hairstyle didn't adhere to the grooming guidelines. Again, the 18-year-old has spent over half of his junior year in-school suspension. Before today's hearing, Darryl talked to us and other media about the impact of the situation that all the suspension has had on him and his academics.
It's put a lot of emotions on me, you know, anger, sadness, you know, disappointment, and my bad.
No, it's okay. Take your time.
Apologize for how they make you feel.
Do you feel like they're robbing you a little bit of your childhood and your high school career?
Oh yeah, for sure. No doubt about that. I don't know, it just makes me feel angry, very angry that, you know, throughout all these years, throughout all the fighting for the black history that we've already done, we still have to do this again and again and again. Is ridiculous. It makes no sense.
Joining us now is Allie Booker, the George family attorney, plus Ron Reynolds. He is the Texas Legislative Black Caucus chair. Allie, first and foremost, do you plan to appeal this ruling? Is it appealable?
It is, and we do plan to appeal this ruling.
So when the judge said that he was violating the hair policy, I'm still confused because their policy deals with length. His locks do not go past his ears.
And that is exactly our argument. But they believe that they can control how long the hair is in totality when it is let down, not when it's worn at school. But that's
what's so strange, because when it's let down, if it's not let down at school, how is he violating it?
We agree.
That's like saying they're going to regulate a woman's hair length, but if she's wearing it in a bun, well, we can still regulate that because it's in a bun, but it's not down.
Absolutely, and that's why we believe that it's overbroad.
The school district, of course, has been very aggressive in this. The superintendent has took an ad out in the newspaper as well. What do you think is really going on here?
Well, guess what? Before I started this interview, I received an email. And this email is from Greg Poole and David Bloom. David Bloom writes it and says, Dr. Graham, this is, I guess he wants me to read it. He says, Dr. Greg Poole has been the Barbers Hill ISD superintendent since 2006. Here are Dr. Poole's comments on today's verdict. The Texas legal system has validated our position that the district's dress code does not violate the Crown Act and that the Crown Act does not give students unlimited self-expression. The United States Supreme Court recently ruled that affirmative action is a violation of the 14th Amendment, and we believe the same reasoning will eventually be applied to the Crown Act. Mm-hmm. High expectations have helped make Barbers Hill ISD a state leader. Falsely claiming racism is worse than racism and undermines efforts to address actions that violate constitutionally protected rights.
So I'm sorry, they actually invoked the Supreme Court's ruling on affirmative action, and they think the Supreme Court is going to invalidate the Crown Act?
They do, based on the fact that they believe it's unfair. They're claiming reverse racism. I thought it was funny. You know, they sent it to me and then said it was a media blurb per se. But it answers your question, right? Where's their mind at? Affirmative action. I'm going to take away anything for blacks.
Ron Reynolds, you're in the Texas legislature. Go to my iPad. This is the actual law. It says prohibition on certain discrimination in student dress or grooming. In this section, protective hairstyle includes braids, locks, and twists. Any student dress or grooming policy adopted by a school district, including a student dress or grooming policy for any extracurricular activity, may not discriminate against a hair texture or protective hairstyle commonly or historically associated with race. I'm sorry, I'm confused here. That's the damn law.
Roland,
How does a judge write this decision when the law is explicit?
Brad, this is a shame on the judicial system that this judge rendered this opinion that's contrary to state law. This was a affront to bipartisan bill that protects students like Darryl from being discriminated against from the very same district, by the way, that we filed the damn bill in the first place, because they did it to DeAndre Arnold 2 years before. So we filed the Crown Act so that Barbers Hill will stop discriminating against students, black students, for wearing braids, locks, or twists. And here it is in 2024, deja vu. Barbers Hill says, yeah, y'all passed the Crown Act, but we found a loophole. You didn't talk about limb, so we're going to have a policy that just says you can't wear it past your, well, you put it on the screen. And so therefore, he's in violation of our school policy. So this is discrimination. This is the school district saying either you can conform to European standards or you won't be at our school. And the judge gave them a pass. He turned a blind eye on the law that we passed. And it is a shame. This is an affront to democracy.
Even white legislators agreed, first of all, voted for this. So this is not like it was carried only by black folks.
No, this Roland, you know, you're from Texas. It's hard to pass any legislation in Texas. This is bipartisan. Governor Abbott had a bill signing because they did so much harm to, they did DEI and all that other stuff this session. We don't even touch that right now. But this was like, okay, we did something. Yeah, let's have a bill signing ceremony to show we passed something that had bipartisan support that benefits black people. And guess what? They didn't give a damn about this law. And first of all, the Attorney General and the TA Commissioner weren't enforcing it in the first place. So that's why Attorney Allie Booker had to file the lawsuit. And then the judge then slaps it down today saying, yeah, school districts, if you want to violate the Crown Act, all you have to do is come up with some nonsense about limb, when we know good and damn well that you can't grow locks, braids, or twists without having any kind of limb. So this is discriminatory. It's a slap in the face. I think that Attorney Booker will prevail on appeal, but all while this student suffers and other students who are similarly situated suffer, that they cannot go and learn in an academic environment with their peers because Barbers Hill wants to single out black boys, black young men, and discriminate against them because they don't like braids, locks, and twists.
Allie, how's Darryl taking this ruling?
He's taking it hard. He wasn't born during the civil rights era. This is a new era, and it's like they're trying to repeal and attack all of the laws that protect minorities. And so this is a new, younger generation that has to deal with that. And it's tough on him, right? Because to these children, they've experienced racism, but not in the way a lot of us have. So he's highly confused by it all.
Well, some things change and some stay the same. Allie, keep us abreast what happens with this case. Representative Reynolds, I appreciate it. Thanks a lot.
Thanks, Brad.